Hi, I'm David Cantor with the Law Offices of David Michael Cantor, and welcome to my blog. Today's topic has to do with former U.S. Supreme Court Justice John Paul Stevens criticizing the death penalty in America. Now, what's going on is Stevens was appointed to the U.S. Supreme Court in 1976, and 4 months after he took the bench, he voted to reinstate the death penalty. Since that time, 1,100 executions have occurred in the United States. And in 2008, Justice Stevens said, you know what, the death penalty is unconstitutional. But he really didn't expand on why he thought that. Well, he has since left the bench, and there's a new essay coming out in the New York Review of Books. And there's a book written by David Garland entitled Peculiar Institution, America's Death Penalty in an Age of Abolition. Now, what happened was the New York Review of Books sent the book to Justice Stevens and said, will you review it? And he said, yes, I will. And he did review it. And his essay has been published online, but will not be fully released until December 23rd of 2010. And basically, he said he opposes the death penalty because there is regrettable judicial activism. He says that the death penalty implementation is full of racism, it's skewed towards conviction, it's infested with politics, and it's tinged with hysteria. Basically, what he's saying is it's not applied fairly, and it's definitely applied unfairly towards minorities. One of the things he said was he finds it unusual that if a black man kills a black man, usually death is not imposed, but it's imposed much more frequently if a black man kills a white man. And that was pretty interesting. In the case of McCleskey versus Kemp in 1987, there was a 5-4 decision that allowed, in essence, according to Justice Stevens, race-based prosecutorial decisions. And he's never liked that opinion. Basically, he says that local prosecutor elections are affected by have affected prosecutors' death penalty decisions. Because they want to be elected, they impose the death penalty more often. And basically, there's an article that's coming out by the Arizona Republic that will be coming out shortly that talks about Andrew Thomas's decisions for death penalties. And after Rick Romney came into office, he threw out half of those death penalty cases. What I mean by threw out, he threw out the notice of intent to seek death and reduced those. In fact, one case was dismissed in its entirety. That would be Lisa Randall, my case, which is we've discussed many times in my blog. The last thing that Justice Stevens said that I've always agreed with this, and most defense attorneys do, he says that they should not automatically strike potential jurors who have qualms with the death penalty. Now, what happens in a capital panel when you're selecting a capital jury, which I've done before, is if anyone says, I have problems with the death penalty and I don't think I can impose it, they're automatically struck. So what you're left with is an entire jury that's pro-death penalty that's skewed towards the death penalty. It's not an accurate cross-section of the community. And Justice Stevens recommends that you don't automatically strike people. You simply say, that's fine if some say, well, I have a real problem with it. Okay, what about in certain situations? Yeah, but it'd have to be very extreme. Well, no kidding. I understand that. It should be very extreme because death is different. But that's what I think. Tell me what you think.